Several of them at the time, and the Attorney General were running for election. The Attorney General ran successfully for election to the Senate, and the Court of Criminal Appeals judges faced battles for re-election. They're still upset with this case. They found all the major issues presented to have been procedurally defaulted, even though there was no procedural rule that was violated. And at this point, the only way there's any opportunity to get relief at the habeas corpus stage is if we get assistance from the U.S. government with an amicus brief to try to convince the court to grant us an evidentiary hearing. This is a case where the racial discrimination was never overcome, because while a second trial was provided for, a second trial under circumstances where the person is said to be a future danger based on misconduct during his last 3 years on death row, because a full day of testimony at the second trial was testimony by prison guards of how he acted out on death row in ways that wouldn't have occurred if someone wasn't in severe isolation. That's not restoring the status quo ante. The only way to restore the status quo ante at this point is by converting the sentence to life imprisonment. We're very open to the Commission offering its services to try to facilitate a friendly settlement in this case. Because the racism hasn't been cured, the Argentine government has done what it can to try to cure the racism at the trials. But unfortunately, to date, it's been a rather futile effort. Well, futile partially. Of course, 8 other cases were reopened. A law was passed thanks to pressure from the Argentine consulate eliminating the use of race in death penalty sentencing in Texas. In the event that the U.S. government is unwilling to take concrete steps now to assist Victor, then the most appropriate action for the Commission would be to decide the case on the merits, perhaps in combination with a visit to the death row in Texas, so the Commission can appreciate firsthand the conditions under which Víctor Saldaño is being held. Thank you.
Agradezco a los peticionarios por su presentación. Tiene la palabra por 20 minutos la representación del Estado de Estados Unidos.
Thank you very much, Mr. Chairman. Distinguished Commissioners, the Government of the United States appreciates the work of the Inter-American Commission on Human Rights and firmly believes that the Commission's function remains a vital part of our inter-American system. With this in mind, we are pleased to participate in today's hearing regarding Case 12-254, Víctor Saldaño. I am Andrew Stevenson, alternate U.S. Representative to the United States, of the United States to the OAS, and also joining me today in representing the views of the United States government are Gwyn Kinsey, Deputy Chief of the Capital Case Unit of the Criminal Division of the U.S. Department of Justice, Gilda Brancato of the Office of the Legal Advisor for Human Rights and Refugees of the U.S. Department of State, Andrew Shepard, Office of the Legal Advisor for Human Rights and Refugees, also U.S. Department of State, and Ms. Chaz Holm of the U.S. Mission to the OAS. Mr. Chairman, the U.S. Mission to the OAS is fully committed to advancing Secretary of State Clinton's call to renew America's leadership through diplomacy that advances our security, enhances our interests, and reflects our values. Our participation in today's hearing is a clear reflection of this call. The United States is also pleased to extend to the Commissioners and the Executive Secretariat staff of the Commission very warm congratulations upon the 50th anniversary of the Commission. Regional human rights bodies and monitoring mechanisms, such as the Commission, give civil society, especially human rights defenders, an established and accepted channel to communicate human rights concerns to governments and encourage regional attention and cooperation on human rights situations. Distinguished Commissioners, in making our statements this afternoon, the United States underscores the importance which we attach to the international and the inter-American community addressing the critical human rights situations of our day. Thank you very much, Mr. Chairman. I'm now pleased to pass the microphone to Ms. Gilda Brancato of the Department of State's Office of the Legal Advisor. Thank you.
Thank you very much. Commissioners, good afternoon. petitioner, and everyone assembled present. Good afternoon. I will present the first part of the United States government's response to the petitioner, and then we'll turn the case over to my colleague from the Department of Justice to address the matters raised by petitioner. Of course, the U.S. government has listened very carefully to the presentation today. We've read the papers and the petition that has been filed. And certainly, the United States expresses compassion for the difficulty that you've expressed today on behalf of the petitioner. But with due respect for this difficulty as a matter of law, the United States takes the firm position that where there is available strong constitutional protections, including the availability for the first time of an ongoing federal habeas petition to address the allegations that are claimed about the 2004 hearing, that the American Declaration is respected and the rights are respected through strong judicial guarantees and oversight in the federal judiciary. Petitioner certainly claims that Articles 1, 2, 18, 25, and 26 of the American Declaration have been violated. Each of these rights is fully protected under United States Constitution and laws and through the mechanism of providing the remedy of the writ of habeas corpus. As I listen to the heart of petitioner's presentation, we believe it is that essentially the 2004 hearing did not cure the allegations and the violation found by the United States Supreme Court and by the federal habeas court in an earlier proceeding stemming from the 1996 hearing. The United States does not dispute that the 1996 hearing was tainted by racial discrimination. Of course, the case found its way through the state and federal court system, and the Supreme Court remanded the case for the Texas Attorney General's confession of error, and through federal habeas proceedings on the 1996 death sentence, that was vacated. The heart of the petitioner's claim of a new allegation is the 2004 hearing. The United States listens carefully to the claims to the errors of law cited by petitioner and notes that it wasn't until October 26th of 2009, last week, that the petitioner availed himself of the federal habeas corpus remedy to challenge the conduct of the 2004 hearing. Therefore, the petitioner has just initiated this robust, independent federal judicial review of the claims they said that tainted the 2004 hearing. As you know, we reject categorically that the habeas corpus proceeding is a fig leaf. There's a strong, robust federal judiciary. Earlier in this particular case, the Supreme Court and the federal judiciary vacated the earlier death sentence. If new constitutional errors have occurred, the federal court is equipped with the expertise, the constitutional background, and the competency to give petitioner the relief that he alleges. Here, as we mentioned, the federal habeas petition, which is 170 pages, just filed last week, raises several of the claims raised by the petitioner before this proceeding. In addition, there are affidavits, of course, providing a factual basis for the fact that there were errors alleged by plaintiff in the 2004 hearing. Principal errors being alleged by plaintiff that the court did not sua sponte entertain a competency hearing, and also that the court improperly rejected the evidence offered by their psychiatrist and refused to provide appropriate guarantees for a competency issue. But each of these claims have just now been brought before the federal court. The federal court has the opportunity to address them, to give an evidentiary hearing, and to provide any appropriate relief under our constitutional system. I will turn over the case shortly to my colleague from Justice to give further